Odofo sisi anu Ghana topic aye discussion obia kan ho asema jese ofa ase ye kan ho ase ofa ase ye kan ho ase sisi anu ye the petition kese tintin pan de kojondo amani ma na so ye say ni menim ya no aye acting anase appointed chief justice no aye Paul Bafuboni no ye yini fi akonja so because ne juma enso eni odofo amanfo no body petition kese pan de akọ edi ama eye John Dramani Mahama say ni menim ya no onyi aye acting anase appointed chief justice enfi akonja so mo be kai say yankese ye maame getu tokonu ne nsem no aye deja ye maame sisi na me no kase ondayo ogusu ne nam quarter se court bedi na asema ma no odofo sisi anu amanfo bebre na si abaye de bo techi ni de eno ana ebebo ban because ekonomode eye getu tokonu fast no amanfo bebre na so mo nti ase ewo se ye di appointed chief justice no so ono so also ye dey stand so the same thing as ye dey no odofo bebre na atinase no mo se dabi se ye the petition tintin ade ko John Dramani Mahama na so ye se na be ye ni menim ya no obeyi eye appointed chief justice eye Paul Bafuboni efi akonya so tisi ame na okasa no ye the petition tintin ade akọ ana manfo bebre na se hwe dabi o NDC for omodi ye NPP for dia and the same thing so ene enso be ye omo ntina manfo bebre na se ade omodi ye getu tokonu no na NDC for my din no mo nkan wasem no in there obinso at the petition tintin dia ko John Dramani Mahama ni office enimenim ya no ye yi Paul Bafuboni ono so appointed chief justice no ono so ye yi fi akonja so dofo sa discussion we another sa topic we na e deja Ghana ase ye obi aka ho asema me so bedi ni nyina brew odofo ensem no de aye deja obi aka ho asemu yese sakino acting chief justice o appointed chief justice o Paul Bafuboni o de juma nso eni o John Dramani Mahama ye the petition tintin abrewo yese sakino chese discussion tintin ekoso Ghana ha do fo manko ne enko tua sanse mu nyina so Ghanatube mraisia.
Move to the petition of the removal of the chief justice. Yes. So, Wanda, have you seen that petition? What do you make of it?
I will defer. I will come back to that.
Well,
let him take it.
It's a lie. It's a lie. You are not deferring.
I will come back to the lawyer.
It's a lie. It's a lie.
I said I will defer that to him. I will come back to who?
Can I take his position?
No, if you are deferring,
you can take it.
Defer the power back.
I'll defer to you.
I'm ready.
Why?
Okay. I'm ready to go.
Why? What's ready to go? Why? Why do you not want to comment on it?
Oh, no particular reason. I will comment. I will comment. Just that I'm saying. But for now,
before you come in, let me deal with it.
They are in a hurry to
do you know each other?
I don't know
who.
Kamal and
MPP members.
I know him. I know all of them here. I know him better. This guy.
They are all members of the MPP.
Because I see how you're happy to give some of your seconds.
No, I'm saying I want to take all.
Kamal says he wants to come in. No, you went back.
No, it's not my turn yet. He said he was.
I told him he gave it to me.
Oh, he should give it to you.
He gave it.
You choose who?
He gave
okay, very well. I didn't hear that one. I didn't hear that one.
I'm happy to come to you.
Okay, that's fine. You see, when they say he who brings sugarcane home is the one who invited the flies.
It's not true.
The one who brings sugarcane home. This is the literal translation from the Akan proverb. You see, I have always gotten worried about how we are treating our judiciary, and if we are not careful, that is the only safe haven we should have. Sadly, it may appear the very hostile ground that we rather have, if you are not careful going forward. Triggering Article 146 of the Constitution, okay, and then staying put to say that you are dealing with the law, okay, is what has given birth to some of these petitions. The petitioner, in this case, his name is Yusuf Bande. I don't know whether he's a brother to whoever, but Bande, his name is Bande. I've seen Yusuf Bande somewhere.
No, Yusuf.
Eh?
Nubin Yusuf.
Bande Yusuf, right? Nabin Yusuf. Yeah. Okay, very well. But importantly, there's Bande and there's a Yusuf. Okay? The petitioner is citing misconduct and has alluded to the code of conduct of the judiciary. Rule 1, Rule 3, Rule 4, and so on, and Rule 6 and so. And his argument is all about where a case or a matter is before a court of competent jurisdiction, in this case, the apex court of the land. The case appears sub judice. And therefore, no one should what? Comment or say anything about it. Not even a judge. Reference is made to lawyers visiting the acting Chief Justice. Whether known to him or not known to him, a matter is laid before the competent of court for decision to be taken. He had comments on it, which comments to a large extent appeared prejudicial to many. Therefore, it warrants what Bande believes in his analogy and interpretation to what we call misconduct. And if that is misconduct, and citing the Bangalore principle adopted by the UN, then of course it stands to reason that a prima facie case be established on this matter, and then triggering the processes in 146 to move on to remove a judge. You see, that is why I'm saying that he who brings sugarcane home, you invite flies home.
Is this? What do you? Have you read the petition?
I have read the petition. I've read it. I've read the petition.
Okay.
It's about. I'm not like you. I read document for ICT. I don't do that. No, I'm not like you. Anyway, you should know. No, I read everything to the end.
You should have came home and buy flies. So that is your time, and you said to him.
So
he who brings sugar cane home.
He who brings equity or calls for equity must also do equity. This matter has actually come. We want to see the logical conclusion of it.
Okay.
We want to see how the president is going to forward that to the Council of State. We want to see how Article 146 per the principle used yesterday, that same principle is used today.
Before that,
so that at the end of the day, Ghanaians will see fairness in the end.
Before today, when Article 146 was triggered.
When we think of beads, we often imagine beautiful, small.
In the petition to remove the former Chief Justice.
Yes.
Were you part of the people that believed that Article 146 was quite problematic?
I have.
You do. So why then do you want it to be triggered on this one? If you think it has a problem, then why does it not have a problem now?
That is why I'm saying that you set a precedent. We are dealing with judicial precedents in this country, and that is part of our laws, our institutions. Read Article 11 of the Constitution of Ghana.
Basically, what
tells you decisions that was made becomes is binding. So I am saying that what you have done yesterday becomes law. And if it becomes law, it will come to bite you if you are not careful. So I am saying that what has happened today is just somebody following precedents.
Beyond the commentary, what do you make of the petition yourself?
You see, obviously, if there is a citation, you don't just make petitions in a vacuum. You make petitions, and that is why I always like legal arguments. Legal arguments are grounded in references that you make to back your argument. Legal argument. So the point is that the petitioner cited the Code of Conduct of the Judiciary and cited Rule 1. And so on to Rule 6. It means that he has a backing to his case. He may have his interpretation, but that is the backing. And then based on that, he has actually petitioned the president, say that, look, XYZ happened, and this happened for me amounts to sub judice, and that sub judice, if it's done by a judge, amounts to a misconduct according to the Bangalore principle. Therefore, I am out there. So for me, I think what happened yesterday is what somebody has stood on and actually have had meat to support whatever he has as a claim in form of a petition.
Okay, Nanel.
Thank you, Emefa. I think that it's an interesting petition when I read it. Now, just before I come to the petition, so the issue has to do with the fact that some group of lawyers think that the Ghana Bar Association has overlived its wordiness.
Operating quite a monopoly.
And operating a monopoly, of which I have been for that school of thought for a very long time. And I think many Ghanaians and many lawyers have also called for some lawyers to also put themselves together and set up themselves against that. And I remember giving an example of those days back when almost every now and then you find teachers going on strike here and there, until we started having sister associations like the Concerned Teacher Associations, we have Graduate Teachers Associations, and that reduced the monopoly of NAT and reduced their over-politicization of issues. And that is what we find in the Ghana Bar Association, and to which a group of individuals, these lawyers, decided to put themselves together and said that, listen, if you look into our constitution, I decide which association to join as an individual. Let us not forget that the Ghana Bar Association is not a licensing authority, but they have been given that mandate in terms of even renewals.
So I don't want to talk.
You get it. So in from where I sit, I think that if they had gone to meet the acting Chief Justice and has stated their stand and he had passed a commentary on it, and the petitioner thinks that it's a breach of regulations, and for that matter he should be impeached or should be removed. Of course, he has written his petition.
Why did they? But the matter is in court. What was their business going to see him?
No, you see, the aspect of the case being in court was different from the aspect of the case or their courtesy call they had put on.
That's optics matter at all.
So
optics matter.
If that's
why there should have been discretion. So commenting on it.
So what I'm saying is that
you understand,
if he decided to comment on it because it was a courtesy call. Now these are lawyers who have decided to take a particular stand and they are visiting him and he's decided to pass a comment. There is a case in court, of course. They have the right to do. The petitioner has the right to go ahead with it. And triggering Article 146, I have said that if Article 146 can be triggered 10 times in a year for there to be sanity, all right, in our judicial system, I do not mind. Why? Because the judicial service system is the only safe havens that we have as a country.
Yes.
So I do not have a problem. But you see, we cannot sit here and determine whether or not the president would interpret this as having the substance to go through a process. The president is listening. He has read it.
If malpractices were substance,
if the president decides that he should go through the process of Article 146, of course, that is up to him. You understand me? And I think that the language of the petitioner is very clear, whatever he has written. But I would be surprised if it is able to meet the conditions. I would be surprised if it is able to meet the conditions that would have to go through to be able to.
You would be surprised.
To the end of it. I would be surprised. I mean, this would be definitely aborted before time. I mean, let's be clear.
Thank you very much. Yesterday,
QuickBooks gives me the superpower to automate my invoices, track expenses.
in fact, something just happened today that for me is humbling and that everybody must look at it. The fact that my brother, you're talking about the removal of Chief Justice, and my brother here says, somebody else, take my slot, I won't talk.
I didn't say that.
My brother came here to talk. But for the first time on this, we are talking about something, and he says, I won't talk.
Correct me if I'm wrong. Yes. Some days ago, you were here as a panelist when we talked about the teacher-student abuse.
Yes.
And we asked that you make a comment.
Yes.
Do you recall that you made a comment or not?
I did.
Because you didn't. You deferred. You didn't make a comment.
I deferred. But I never said that.
He's a teacher.
Wrong.
Who told you?
But did you?
I made a point.
You made a point. You did.
I made a point.
If you made a point,
This matter has nothing to do with
MFI, I made a point. You can.
No, he's made a clear.
Order for one whom some na ekoso e wo studio they say studio ha ebutubutu je say discussions na ekoso din yentie e say eye petition akese pan order letter tintin e dey akọjọ ndo mari ma ne office ni menim ya no omunyi eye acting and as appointed chief justice for bafubọ ninu enfi akonja so because ne juma enso in order for bebre na akase NDC for mo balance yan ade ambodi e get to kono enua bi nso a ne yenso be yomodofo etisi amana okasa no ene topic for discussion ofa asia na ye kan ho asem ofa asia na ye kan ho asem ena mi nso beji ni nyina abra e wo Ghana chodofo se oni omo ya adwin petitioner na ya adwin se ni menimi ya no acting chief justice na se appointed chief justice for bafubon ne juma nso eniti no onfa na juma nto ana se onfi akonya so a for comment ni nyina Facebook mi comment section na making kan ni nyina mo do for aha and I'm doing na base mamu fi so like na subscribe na ma share na ma hit notification bell so ma say na be ya bring ya bibia do pe content say ya mu bonya ne tempa na ma hwe meet do for aha and I'm doing say me na be see Ghanatube so makra mu nyina medam nyina celebrate